This PowerPoint and narration was created for East Texas Baptist University Criminal Justice Course 1311, Fundamentals of Criminal Law, and I'm Eric Hillman. This PowerPoint slide is based on the textbook Criminal Law, 12th edition by Joel Samaha. This PowerPoint is intended to supplement and not replace the student's reading of the textbook. This is Chapter 4B, meaning that Chapter 4 in the book has been divided into several different sections in order to keep the size of these files down. So since this is Chapter 4B, my assumption is that you've already watched and taken notes on Chapter 4A. The last slide in Chapter 4A video was the 4 mens rea that exist in the Texas Penal Code. From highest to lowest, as you recall, we explained that they were intentional, knowing, reckless, and criminal negligence. We also, in video 4A, discussed the concept of strict liability, where you could be found at fault for a crime even if you had no culpability, so to speak. But with these 4 mens rea, I think we need to discuss each one a little bit more thoroughly so we can describe what each one means. We're going to cover the definitions in the Texas Penal Code since we are a Texas school and most of the students in this class who enter law enforcement will be working in a Texas agency. So, Chapter 4B, mens rea, concurrence, and mistake. Let's first look at what we mean by intentional. This is found in Texas Penal Code 6.03. I won't test you on the exact numbers, 6.03a, but you do need to know the definition of intentional. In the Texas Penal Code, intentional means conscious, objective, or desire to engage in the conduct or cause the result. So in this picture, you see one man assaulting another, and as he takes his leg and stomps on the other guy's head, it certainly appears to me that his conscious objective is to engage in the conduct of assault or to engage in the results of bodily injury to the person on the ground. So he intends to do this. The second level is called knowing or knowingly, found in Texas Penal Code 6.03b. The definition of knowing is aware of the nature of his conduct or that the circumstances exist, or aware that his conduct is reasonably certain to cause the result. So perhaps it's not this man's intention to hurt someone, but he knows that based on what he's doing, certain circumstances exist, and based on what he's doing, his conduct is reasonably certain to cause a result. And we'll actually give an example that compares all 4 of these mens reas right next to each other once we get done with the definitions. Penal Code 6.03c. The definition of reckless in Texas is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. So I've underlined there aware of and disregards. This is a key to distinguishing the term reckless from the term negligence. So as you see this man standing up on a motorcycle, showing off perhaps, he's driving down a street, perhaps there's a crowd gathered to watch him, and if he crashes and hurts someone in the crowd, the jury has to ask themselves, assuming he's charged with reckless injury, was he aware of a substantial and unjustifiable risk? Well, certainly he is. If you ride a motorcycle down this crowded street, standing up and not steering it, there's a substantial and justifiable risk that you will crash and someone will get hurt. So he's aware of it. Did he consciously disregard it? Well, in this case, it seems clear that he did. If he saw other people on the street and he still engaged in this behavior, he disregarded it. But then you see in capital letters the word "and." This act is a gross deviation from the standard of care that ordinary person would exercise. So would an ordinary person stand up on a motorcycle and speed down the street when there's a crowd of people nearby? No, it isn't. It's not just a deviation, it's a gross deviation from that standard of care. And so if this person crashed and perhaps killed a bystander, he certainly didn't intend to kill a bystander, and he didn't know that a bystander would be killed, but he was aware of and consciously disregarded a substantial and unjustifiable risk that a bystander would be killed, and that act was a gross deviation from the standard of care that an ordinary person would exercise if they were riding a motorcycle down a crowded street. Criminal negligence. The definition found in Texas Penal Code 6.03D is that the person ought to be aware of a substantial and unjustifiable risk that the circumstances exist or the result will occur, and there's that word "and" again. Failure to perceive the risk constitutes a gross deviation from standard of care that an ordinary person would exercise. And so in this picture you have a car that's crashed into a store. Perhaps this person had left the store and they thought they put the car in reverse, and they then hit the gas, but they had accidentally put the car in drive. And because it was in drive when they hit the gas, it went through the front door of the store and perhaps killed a sales clerk working inside the store. First of all, is this negligence? They ought to be aware of a substantial and unjustifiable risk that the circumstances exist. So, first of all, was the person intending to kill someone? No. So it's not intentional. What about knowing? Did the person know a person would be killed? No. Reckless. Were they aware of the risk? Did they know that they were in drive instead of reverse? Of course not. Then go down to negligence. Should they have been aware? They ought to have been aware that they were in drive instead of reverse, yes. Was hitting the gas when you're in drive instead of reverse a substantial and unjustifiable risk? Yes. And was failure to perceive the risk a gross deviation from the standard of care that an ordinary person would exercise? Well, that's up to the jury to decide. In circumstances like this, as a former accident investigator for the Houston Police Department, I have seen juries find drivers guilty of criminally negligent homicide because their failure to perceive that risk that they were in the wrong gear was a gross deviation. An ordinary person would look to see, am I in drive or am I in reverse before they hit the gas? And so that would be criminal negligence. The key then is that reckless and negligence differ in that in recklessness, the person was aware of a risk and disregarded it. In negligence, the person should have been aware of the risk, and their failure to perceive that risk was a gross deviation. One way to explain the difference between these four is to give the airplane crash example. So let's talk about each of the four. Let's say I'm a terrorist or I'm a hired killer, and I find out that John is going to be on the airplane. I want to kill John, so I put a bomb on the airplane. By putting the bomb on the airplane, I am intentionally trying to kill John. That's my conscious objective, to kill him. But then I find out that John's sister Mary is on the plane. And I think to myself, oh, Mary's such a nice person. I don't want her to die. But you know what? If I take the bomb off the plane now, then I won't accomplish my objective of John dying. So I'm just going to leave the bomb on the plane. Was it my intent to kill Mary? No. But did I know that because of me putting the bomb on the plane, Mary would die? Yes. So I am guilty of intentionally killing John, and I'm guilty of knowingly killing Mary. What about recklessness? Well, let's change the facts a little bit. Let's assume that I'm a mechanic working for the airlines, and I am told to check the hydraulic hoses on the plane. But I work 8 a.m. to 4 p.m., and I get off at 4 p.m., and I really want to get off because I have a hot date at 5 p.m. I need to get home and change and get into my dancing clothes. Well, I check the hydraulic hoses, and sure enough, there's a serious leak in one of the hoses. And I say to myself, well, this plane has flown 5 flights today. It'll probably make it to the next airport. So I'm just not going to fix it, because if I tell them the hydraulic hose needs fixing, well, guess what? I'm going to miss my hot date. So I just close up the compartment and I ignore it. The plane then crashes. Well, if the plane crashes, I could be charged with reckless homicide or manslaughter because I was aware of that a condition existed, namely that the hydraulic hose was leaking, and by me ignoring that risk, that was a gross deviation from what a reasonable mechanic would do. So I could be charged with reckless homicide or manslaughter for anyone that died on that plane. What about negligence? Well, we could continue with the airline mechanic example, and this time change the facts a little bit. This time I'm told, go check the hydraulic hoses, but I don't have time to check them and make it to my hot date, so I simply don't check it. I think, well, the hydraulic hoses on these planes are always working just fine, so I simply don't check it. Am I aware that the hose is leaking? No, I'm not. But let's say the hose was leaking, then the plane crashes. If I was aware that the hose was leaking and I ignored it, that would be recklessness. But in negligence, I ought to have been aware. That was my job to find out. I ought to have been aware it was leaking, and I wasn't aware. But my failure to perceive that the hose was leaking was a gross departure from what a reasonable mechanic would do. So reckless, I knew of the risk and I ignored it. Negligence, I didn't know the risk, but I should have known. And so in the last example, even if I didn't know the hose was leaking, I could still be charged with criminally negligent homicide because I should have been aware as the mechanic. It was my job to check it and I didn't. So now let's look at some court cases that deal with different levels of mens rea, and we'll see sometimes the difficulty in the judge or jury deciding what level of mens rea is associated with a certain crime. So this is State versus Stark, a case coming out of Washington State. Mr. Stark tested positive for HIV. Now keep in mind this is 1992. And this is before they had a lot of the drugs available now to help keep HIV contained. But he tested positive for HIV, and in 1992, this was still considered a deadly disease. The doctor told him, do not have unprotected sex, and before you do have sex with anyone, you have to tell your sexual partners before having sex that you're HIV positive. Well, as you can imagine, Mr. Stark didn't want to tell his partners because he figured if he told them, they would simply say no. So he had unprotected sex, no condom, no protection, with 3 women without telling them that he was HIV positive. However, he told each woman after he had sex with them. The women get with the health department, and the health department issues him an order, cease and desist order. So this is an official government order that he's required to follow. But Stark Stark refused to stop having sex with women unprotected, and he refused to tell them ahead of time that he was HIV positive. Later on in his trial, one of his neighbors testified that, I don't care, if I'm going to die, everyone's going to die. Mr. Stark was charged with assault with intent to inflict bodily harm by exposing or transmitting HIV. This is the wording of the Washington law, and as you can see very clearly, it uses the word intent. Therefore, in order to convict Mr. Stark, the district attorney needs to prove intent. Did Mr. Stark have a conscious objective to inflict bodily harm? Did he have a conscious objective to expose or transmit HIV? Was it his intent? Well, Mr. Stark said, I didn't intend to spread HIV. That wasn't my conscious objective. All I intended was to get sex. The jury disagreed with Mr. Stark. They found him guilty of intending to inflict bodily harm by exposing to HIV. And they gave him 13.5 years in prison based on future danger to the community. So a jury has to decide when they're sentencing if the person will be a future danger to the community. In this case, they said, yes, Mr. Stark, if you are willing to have unprotected sex with women and not tell them that you're HIV positive, we believe that you'll continue to do so in the future. And so at least partly because of that, they gave him 13.5 years in prison to protect the community. And of course, Mr. Stark's going to appeal that. And he says, I didn't intend to do it. The appeals court looks at the case and says, well, you knew you were HIV positive. You were told to use protection. You didn't do it. You were told to warn partners. You didn't do it. And this is the key. He told the neighbor that he didn't care if everyone died. That, in the appeals court's mind, was intent. That was a conscious objective to expose people to HIV to cause bodily harm. And so the appeals court agreed that Mr. Stark could be convicted of a crime involving intent. In another case, this one coming from Massachusetts, Mr. Barnett, who is black, yelled at his neighbor Acuna. She is a female Hispanic neighbor. And there are neighbors that aren't getting along. He's yelling over the fence. And he says, among other things, you bitch, you damn Mexican, go back to your country. You take our jobs and houses. I can come in your house if I want to. I'll kill you if you say something. I will beat the effing shit out of you and your son. I will kill you both. So he's obviously very angry with his neighbor. And since it's Commonwealth versus Barnett, by the way, most states would charge you state versus Barnett. For instance, state of Texas versus Barnett. But other states call themselves Commonwealths, specifically Massachusetts and Virginia. But Mr. Barnett is then charged. Ms. Acuna calls the police, they make a report, and they bring it to district attorney, and he's charged with assault hate crime. So this would be assault by threat. He's threatening to do them bodily harm, perhaps to kill them. And because it's charged as a hate crime, the possible punishment is more severe. So if you look at the Massachusetts statute, it says that this assault is a hate crime if it's done for the purpose of intimidation because of a person's race or national origin. So did Mr. Barnett yell at his Hispanic female neighbor for the purpose of intimidating her because of her race or national origin? And it would appear from the wording that he used that it was based on her race or national origin. Mr. Barnett says, yes, I was angry. This is just an argument the neighbors have over the fence. I was motivated by my anger, but it was not because of race or national origin. Well, how can when we look inside Mr. Barnett's head? We can't. We can't really know what thoughts he had in his head. We have no way to measure that. And so, as we said earlier, a person's thoughts or their mens rea is something we have to interpret based on their actions. So he says it wasn't based on race or national origin, but the jury convicts him and he appeals to the Massachusetts Court of Appeals. So the jury says, yes, it was done for purpose of intimidation because of Miss Acuna's race. And the appeals court said, Mr. Barnett, you were yelling anti-Mexican slurs. That is enough to show intent based on race or national origin. So in this case, as we've said before, when you can't see in a person's mind, the jury has to look at their actions and interpret from their actions what their intent or motivation is. In this case, the appeal court agreed that his intent was to intimidate on the basis of race or national origin. So the appeals court affirms Mr. Barnett's conviction. We'll look at another case, this coming out of Oregon, State versus Jancy. Jancy and his friend went with his girlfriend to her ex-husband's house. Well, this doesn't sound real smart. The girlfriend's mad at her ex-husband, and so she brings her new boyfriend, Jancy, and his buddy over to the ex-husband's house. I can tell right away nothing good is going to come of this. So, Jancy's girlfriend goes in her ex-husband's house and starts arguing with her ex-husband. While they're inside arguing, Jancy decides to use a knife to let the air out of the tires of the ex-husband's vehicle. Jancy's friend then pours sugar in the gas tank. And if you're not familiar with that, sugar in the gas tank will ruin the engine. So, no air in the tires, ruin the engine. Jancy was hoping that he would do this unnoticed by the ex-husband. But the ex-husband happened to look outside the window, saw Jancy messing with his car, and ran out the door and chased him. Jancy runs away. Jancy still had the knife in his hand that he had used to let the air out of the tires. Jancy runs away with the knife still in his hand, and he hides in the bushes. So Mr. Jancy has a good argument that he's running away from the ex and therefore not trying to kill him. The ex saw Jancy hiding in the bushes and jumped on him. The ex-husband wrestles with Jancy, the new boyfriend, and during this wrestling match, the ex-husband was stabbed. So now you have a stabbed ex-husband, and Mr. Jancy's charged with the crime. So the question then, since we're talking about mens rea, is did he intentionally stab the ex-husband? Did he knowingly do it? Did he recklessly do it? Or did he negligently do it? Mr. Jancy's charged with stabbing the ex-husband. He says, I didn't intend to stab him. As a matter of fact, I was trying to run away so I wouldn't have a confrontation. He was charged with, and the jury convicted him of second-degree assault, which in Oregon uses these words: intentionally or knowingly causes physical injury to another by means of a deadly weapon. So the jury said, yes, either you intentionally did it, that means it was your conscious objective, or you knowingly did it, meaning it wasn't your conscious objective, but you knew your actions would result in him being stabbed, the ex-husband being stabbed. Mr. Jancy argued, no, it was accidental. He was stabbed while we were wrestling, and it was accidental. To stab him, it wasn't my conscious objective, and I didn't knowingly stab him. In other words, I didn't know that that was going to be the result of my actions. It was all accidental. He's convicted, and he appeals to and says to the appeals court, no, this is accidental. The appeals court said, well, as we look at the facts, Mr. Jancy knew of a substantial risk. He's carrying a knife. He's committing a crime while he's carrying a knife, so there's a substantial risk that the victim of the crime, the owner of the vehicle in this case, could notice him, and it could result in a wrestling match. Not only did he know of that risk, but he disregarded the risk. He disregarded the risk of the victim trying to stop his crime, and therefore, because he knew and disregarded a substantial risk, it should be a third-degree assault, which is, in Oregon, reckless assault. So here the court says, because he knew of the risk and disregarded it, that's actually reckless assault rather than intentional or knowing assault. And coming out of Alabama, a southern case. To round out our northern cases here, Coppersmith versus State. Mr. Coppersmith is arguing with his wife on the porch of his house. She decided she wanted to go inside, and so he grabbed her. I don't want to argue with you. You can't leave, woman. Stay right here. Coppersmith wants to finish the argument. She wants to leave. He won't let her, so then she bites him. And he then, after he's bitten, he reacts, whether it's intentionally, knowingly, recklessly, or negligently is the issue here. But when she bit him, he threw her off the porch. Well, the porch wasn't that high, but she landed on the ground, and there were some bricks that just happened to be on the ground. When he threw her off the porch, she landed, and she hit her head on a brick that was on the ground. And she hit her head so hard on that brick that she died. So, in summary, they're arguing. Wife wants to go inside. Coppersmith grabs his wife. She bites him because she wants to go inside. He then throws her off the porch. She hits her head on a brick on the ground. Is that intentional? I mean, she's dead now. And this is Coppersmith versus State, so he's going to be charged with her death. The issue then is, did he intentionally kill her? Was that his conscious objective? Did he knowingly kill her? Did he know that would result? Did he recklessly kill her? Was he aware of a substantial risk and disregarded it? Or did he negligently kill her? He wasn't aware, perhaps, that she would hit her head on the brick, but he should have been aware before he threw her off the porch. He should have known what was there on the ground. So let's look at those. He was charged with intentional murder. So under the Texas definition, that means it was his conscious objective to kill her. The judge told the jury, well, it could be reckless. It could be that he knew of the risk, but he disregarded it. So you could find him guilty also of reckless manslaughter. Coppersmith testified he didn't intend to throw her off the porch. He just acted reflexively. So she bit him, and he just reflexively, just because of the severe pain of being bitten, he reflexively threw her off the porch. And then he said, but, ladies and gentlemen, jury, if you don't believe that, because if it's reflexive, then there would be no voluntary act at all, right? So he's saying there was no voluntary act. It was like a reflex. Just like the doctor hits your knee and you kick when he checks your reflexes. She bit my ear, and I reflexively, it wasn't a voluntary act. It was reflexively I threw her off. That's what he's arguing. But then he says to the jury, if you don't believe that, well, then at least let me argue negligence. Basically saying to the judge, let me argue negligence to the jury, that I wasn't aware of the risk that there was bricks on the ground, but I should have been aware. Under Texas law, again, he'd be looking at, if he's convicted of negligent homicide, 2 to 10 years instead of 5 to 99 years for intentional murder. So he requests to the judge, let the jury at least consider negligent. The jury ends up convicting Mr. Coppersmith of reckless manslaughter, and he got 20 years in prison for reckless. So that would be a second-degree felony in Texas, 2 to 20. And so So the jury says that Mr. Coppersmith was aware of a risk that she would be killed, and he disregarded that risk. And remember, he said, well, to the judge, let the jury consider the fact that maybe I wasn't aware of the risk, but I should have been. And that would move it from reckless manslaughter, which is 2 to 20, down to negligent homicide, which is 2 to 10. So why is he arguing this in the appeals court? Because if the appeals court agrees with him, his maximum sentence will be 10 years instead of 20, at least under the Texas punishment scheme. The appeals court heard the arguments in this case, and they said the jury could have concluded that his conduct was not intentional and that he was not aware he was creating a risk. The jury should have had the option of criminally negligent homicide. Basically, the appeals court is saying it's possible that he was not aware of the risk, but it should have been, rather than the only option the jury was given above this was that either he intentionally did it or reckless, that he knew of the risk and didn't care, he disregarded it. And so the appeals court said, you know what, it's possible that he wasn't aware of the risk, but certainly he should have been. So the jury should have had the option of criminally negligent homicide. And so the appeals court's going to overturn this case by saying the jury should have been given that option, and they weren't. So the case is remanded for a new trial, this time for the jury to at least be given the opportunity to consider negligent homicide rather than just intentional or reckless homicide. And that's going to bring us to the end of Chapter 4B. Again, Chapter 4 is being divided into several different videos, so the file length does not become excessive. After this, watching this video, I encourage you to watch Chapter 4C. And as we stated at the beginning of this video, watching these videos and taking notes is not a substitute for reading the textbook. It is intended to be done in addition to reading the textbook.